I'm Andrea Volker. I'm a solicitor and mediator at Alternative Family Law. Today I want to talk to you about the case of Jake. Helen and Louise were together for several years when they became civil partners. Helen and Louise wanted to have children. They lived in the US for a time and they tried to conceive through IVF in California. But Helen did not get pregnant. Her biological clock was ticking and she became desperate to have children. When they got back to England, they asked Alex, Louise's brother, whether he would be the biological father for Helen's child, and he agreed. They had a couple of discussions and then agreed that they would have a child and it should grow up with Helen and Louise. Helen later said that Alex provided sperm and she inseminated herself. Alex said that they had sexual intercourse on several occasions and Helen conceived that way. Some months into the pregnancy, the three of them discussed matters further and it became clear that Alex wanted a father's role in the child's life. Helen and Louise did not agree and they fell out. Jake was born in January 2006. Helen and Louise did not allow Alex to meet Jake and to see him. So Alex went to court. The judge very wisely held that it would benefit Jake to know very early on in life the truth about his father, so that he would not find out by accident. The judge made no order about parental responsibility for Alex, but he ordered that Jake should see Alex during the school holidays for about 2 hours at a time. The judge made no finding as to whether sexual intercourse took place. And that was not relevant in this case because it was in 2006 that Jake was born and way before the Human Fertilization and Embryology Act 2008. However, now it would make a difference. Because Helen and Louise were civil partners, if the things that happened now, if there was self-insemination, then Helen and Louise would be Jake's parents. If sexual intercourse took place, then Alex would be Jake's father. So it makes a huge difference. This is based on a real case, which has been reported in the law reports. Jake should now be about 6 years old. Whether he's been allowed to develop a relationship with Alex as a father, we do not know. This case shows how important it is that the adults involved will discuss matters in a great deal of detail and are sure that their expectations and wishes match and that they're clearly set out. In this case, they were clearly not. The judge said, in their quest for action, each heard exactly what they wanted to hear and excluded everything that did not fit with their aspirations. It was a recipe for disaster and so it transpired. This case also shows that since the law has changed, it is so much more important to have contemporaneous evidence about whether sexual intercourse took place or not. It also shows that a judge who is the president of the Lawyers Christian Fellowship is struggling with the factual background of a case like this. Recently, the Court of Appeal decided on a similar case and found that the court should not classify the father as a secondary parent and restrict contact, and that the agreements entered into by the parties in advance cannot outweigh the child's welfare, which is the court's paramount consideration. The Court of Appeal, therefore, in the case of A, B and C, sent the matter back to the High Court for it to decide on staying contact in due course. If you are planning to co-parent or have a child by private donor insemination, you need to make sure that you have evidence in writing and you should get legal advice about how best to do that. That is unfortunately not going to be cheap. If you are a lesbian couple, you may want to think going to a clinic where you have donor insemination, because then the paternity will be very clear and both of you will then be the legal parents of the child. The upfront cost may be high, but you will save legal fees and you will save a great deal of hassle later on if matters go wrong. For more information on this topic, lesbian gay co-parenting and the issues around that, please see the lesbian and gay section of the Alternative Family Law website.